Definition. We would start by saying that there is no generally accepted definition of law. Law deals with a complex phenomenon. Law deals with human behavior, and human behavior is complex. Thus, law has to be complex. Therefore, law has been defined by many scholars and jurists in accordance with their different perspectives or different point of views. According to Thomas Aquinas, the chief proponent of naturalist school of thought, law is simply defined as rule of action. The naturalist school of thought defined law as rule of action as a result of fact that they believe that law and moral rules are the same. They try to equate law and moral rules. Sincerely speaking, in a broad sense, law can be regarded as rule of action because every law regulates an act, both act of omission and act of commission. But in a strict sense, not all rules can be regarded as law. The reason is that there are certain rules which merely represent the notion of good and bad. Such rules are usually referred to as principles of morality, moral rules. For instance, the Bible said, "Thou shalt not commit adultery, thou shalt not commit fornication." These are rules, but cannot be regarded as law, because if people disobey the rules, nothing happens to them immediately as punishment for contravention. Therefore, it is only obligatory rules that can be regarded as law, and rules become obligatory only when it has been accepted by the members of the society to be binding on them. According to John Austin, the chief proponent of positivist or imperative school of thought, law is defined as command of sovereign backed up with sanction. The positivist school of thought defined law as command of sovereign backed up with sanction because of the fact that they believe that law is man-made, not by God, and such law has to state what man must do and must not do. There is element of command in must do and must not do. According to Austin, there are three cardinal elements that must be observed before a rule can be regarded as law, such as element of command, element of sovereign, and element of sanction. In other words, this implies that law must be like a command. Command is an order from superior to an inferior, which if the inferior refuses to obey will attract penalty or punishment. The command must come from a sovereign entity, a constituted authority or a state. That is to say, not all commands are qualified to be law. It must be command that is of general, not of a particular. The command is of general when it is addressed to a community, and it is of particular when it is addressed to a particular person. Finally, there must be a sanction or punishment if someone violates or contravenes the law. For instance, if there is proclamation from the Enugu State House of Assembly that no person shall go out of his house to engage in any business or social activities until it is 10 a.m. on every last Saturday of the month. The question is, should this be regarded as law according to John Austin? Is there an element of command? Yes, because people are made to stay at home even when they have some business to do. Is there an element of sovereign? Yes, because the proclamation is from the State House of Assembly. Are there any sanctions if someone violates the proclamation? Yes. Police will arrest and prosecute the person. That is what John Austin is talking about. According to Oliver Wendell Holmes, American jurist, the chief proponent and avatar of realist school of thought, law is defined as the prophecies of what the court will do in fact, and nothing more pretentious. The realists see law as generalized prediction of what the court will do. From the realist point of view, law is what the court has decided in respect of any particular set of facts through its judicial pronouncement. The realist school of thought defined law as prophecies of what the court can do in fact, and nothing more pretentious, because of the fact that they believe that laws are made by judges, not legislative arm of government, on the basis that laws made by judges are subject to judiciary interpretation, that it is the interpretation given by the judge that becomes law. Therefore, it is very correct to say, according to realist school, that law is only the pronouncement of judges. According to Karl Marx, law is defined as an instrument of oppression, intimidation and exploitation in the hands of the rich against the poor in the society. Law is used as instrument of protection for the interest of the rich people in the society. Karl Marx defined law as an instrument of oppression and exploitation in the hands of the rich against the poor in the society because they believed that law was never made for the interest of the poor, rather it was originally made to protect and advance the interest of the rich in the society. Particularly, from my own perception, law could be defined as a legal instrument used to regulate human behavior in every society. Law is defined as a legal instrument because before law is made, there are certain processes the proposed law must pass before it becomes a legal instrument. The proposed law must be introduced as a bill, and the bill has certain stages to pass before it becomes a valid law. Moreover, law could also be defined as an obligatory rule used to govern a particular society. You could recall that under the definition of law according to naturalist school, that we said that not all rules can be regarded as law. Therefore, it is only obligatory rules that can be regarded as law. A rule becomes obligatory where it has been generally accepted by the members of the society to be binding on them.